Clarification has come from the Ministry Electronic Voting. Section 108 company, I just read it out for your convenience. Section 108 of the Companies, I read with Rule 20 of the Companies Management and Administration Rule 2014, deals with the exercise of right to vote by members in electronic means. The provisions seek to ensure wider shareholders' participation, exactly what I was initially told you, in the decision-making process in the companies, corporates and other stakeholders, while appreciating the new approach, have attention to some practical difficulties in respect to general meeting to be held in few months. Accordingly, it has been decided not to treat the relevant provision as mandatory till 31st December 2014. The relevant notification is being issued separately. Show of hands will not be allowed in the case of e-voting. Participation in the general meeting will not be allowed after voting by e-means. Applicability 20 for matters specified in 2216. Transactions of certain transaction items by postal ballot. In that case also e-voting it has been already exercised by the postal ballot, it cannot be done. Relevant provision relating to demand for poll, that is also not applicable in the case of e-voting. Permissibility of voting by postal ballot under Rule 20. If it has been permitted to exercise his right to postal ballot, then e-voting, question of e-voting, casting voting by e-voting doesn't arise. Manner of voting in the case of represented in the meeting. So all these things have been decided. So all this, in that case, Ministry has issued a circular in that regard. These are the relevant extracts I have given. If you want to have the details, clarification issued by the Ministry, you can look at the relevant clarification in the circular issued by the Ministry, which is dated, I've already told you, that is 30, what is there? Just to see the date. 17 July. 17 July. That is the latest circular issued.
There is only one circular.
There is only one circular. There is one which contains all these details, which gives total clarity to the. And of course, there are certain problems faced by the corporate sector, and that's why this clarification was needed to simplify the procedures. Because as you know, that Companies Act 1956, I've already discussed about that matter, that it contains not only the statutory provisions, but procedures of dealing with those provisions, and also quantitative details. How much fine will be imposed, how many days it will take, ROC reporting will be there. Those things have been separated altogether, procedural and quantitative part. And law has been, Ministry has tried to simplify the legal provisions, statutory provisions, and in that process, this clarification has come out so that it is properly and smoothly can be taken care of by the corporate sector while introducing e-votings in there for the purpose of general meeting. Thank you very much.
Sir, thank you so much, sir. Students would have got a lot of clarity after listening to your talk on e-voting. We have a query relating to rotation of auditors. One student is asking what are the provisions relating to rotation of auditors. In fact, the 2013 Act says for individual auditors, it is one term, 5 years. And for firm, it is 2 terms, 5 years each. So they want an example also. For example, one person is a common partner in 2 firms. For example, XYZ Limited is an audit firm and PQR Limited is an audit firm, and A is a common partner. Now XYZ Limited is completing 10 years as auditors in a company. Whether that PQR Limited, where this A is a common partner, is eligible for appointment? No. Since A is a common partner in both the audit firms, this PQR Limited is not eligible for appointment in that. Sir, one query, one student is asking whether shares issued at discount is totally prohibited under the Act.
No, it is not totally prohibited, as you must be that if you see the provision, what is that? 10?
I think 53, sir. 53 and 54.
53, 54. 53 is very clear that it talks about the prohibition. But if you see 54, then it talks about
it does talk about exception. Except provided under 54. So ultimately the shares can be issued at discount if it is sweat equity.
Sweat equity, yes. Sweat equity, then only it can be issued.
It can be issued at discount. Actually, one more query relating to the syllabus and examination part. One student is asking due diligence for banks is given in the supplement, and I am registered under the old syllabus. Should I read this chapter? Friends, actually due diligence for banks covers some aspect, about 28 aspects. It deals with compliances. It is not directly covered under your syllabus. For your knowledge purpose, we have included it in your supplement to give broader perspective. It is not for examination point of view. You can read it, that may help you in preparing the other checklists that is being asked in other chapters like secretarial audit, compliance certificate and all those chapters. That may help because it covers listing checklist under listing agreement and other related aspects. So it is not directly covered under your syllabus if you are registered under the old syllabus. Yeah, one student is asking for further issue of shares. Whether special resolution is required if it is to be issued to the persons other than the existing shareholders. It is obvious.
Obvious.
Yeah. Special resolution is required, and it is specified under section 62. 62, one of the subsections, it is specified that it has to be passed through the special resolution if further issue of shares are issued to the persons other than the existing shareholders. Sir, one student is asking why the provisions relating to alteration of capital is notified, the provisions relating to reduction of capital is not yet notified.
Reduction of capital requires tribunals.
The same thing, sir has talked about the Constitution of National Company Law Tribunal. Since the reduction of capital involves the role of tribunal, it is not yet notified.
For the purpose of under Companies Act 56, for the purpose of reduction of capital, the company has to go to the court, and on the after the approval of the court, then only company can reduce its capital. Exactly. So the power of the court is going to be entrusted to National Company Law Tribunal.
Exactly.
So since National Company Law Tribunal could not be constituted, that's why this particular section could not be introduced so far.
So one student is asking about the quantum of deposits. Actually, acceptance of deposits, the provisions made in acceptance of deposits, it's one of the very good initiative. It actually classifies. The acceptance of deposits from public as such is not prohibited. It says classifies. It talks about eligible company, and it talks about company other than eligible company, and it talks about government company. Eligible company is a company having net worth of some specific thresholds. I think if I am right, it is 100 crores. And if it is eligible company, it can accept deposits from members as well as public. From members, they can accept deposits up to 10% of paid up capital and free reserves. And from public, this eligible company can appoint up to 25% of paid up capital and free reserves, provided their net worth is not less than the prescribed limit. And if it is company other than eligible company, which is not fulfilling the prescribed limit, having net worth of less than the prescribed limit, then the acceptance of deposit from the public is prohibited as such, and they can accept deposits from members up to 25%, and government companies up to 35% of paid up capital and free reserves, they can accept deposits from the public.